big change to New York's Raise the Age law. You may remember back in 2017, the state legislature passed a bill that moved most criminal cases involving 16 and 17-year-olds to family court instead of them being tried as adults. But now the highest court here in New York has ruled that a 17-year-old who was convicted in a violent robbery is an exception to Raise the Age. He is tried as an adult, and the question is, how will this impact other cases? Who better to ask than John Flynn, who joins us live. He is the former Erie County District Attorney, now a partner at Lippis Mathias Law Firm here in Buffalo. John, it's great to see you. We've talked about Raise the Age for a long time. I know you've had concerns with the law. What does this ruling from the Court of Appeals mean practically?
So it gives it parameters now as far as what kind of circumstances and what kind of cases are going to qualify for an individual who's 16 or 17 years old to get tried as an adult. Now, there are three automatic qualifiers. If someone is significantly injured in a crime, that's an automatic qualifier. If someone displays or uses a gun or a deadly weapon, but mainly a gun, that's an automatic qualifier. The third one is a sexual assault. So if there's any charge on those three specific fact patterns right there, then you're automatically going to have the case be tried in adult court. What this case focused on was the fourth category. So in addition to those three, there is also what they call a extraordinary circumstances exception. So if the DA can prove extraordinary circumstances, then they can keep it in adult court. But up until now, we really haven't had any guidelines or any kind of parameters on what would be an exceptional circumstances. This case gives us that.
And it seems like, based on my reading of it, that the justices basically were saying this was a repeat offender. He had been through family court many, many times. I think a lot of the concern that you've expressed, that the Erie County Sheriff and others have expressed, is, for instance, with stolen cars, right? We have repeat offenders. We have these underage folks who are committing these crimes. And the argument is, should they be tried as adults? Do you think that this will mean we will see more underage teenagers here in New York tried as adults?
Oh, definitely. I'm not sure that stealing a car is going to qualify, though, because there are, in the bill, in the statute, when they made Raise the Age, they did kind of list kind of two factors when you are trying to analyze extraordinary circumstances. One, is it a heinous or egregious crime? And two, does the person have no or not show any ability to be rehabilitated in the social service programs that are given through family court? Now, the stolen car phenomena that we've had a couple of years ago here, if you got a repeat offender who does it over and over again, that you may be able to show that this person, this kid, can't get rehabilitated in a family court. But it's probably not going to meet the heinous crime prong, though. But I do, to the bottom line, your answer to your question, though, I do believe that this case right here is going to open the door, certainly, to more 16 and 17-year-olds getting tried as adults.
When I saw this come out, I had questions, and you've answered them. Former Erie County District Attorney and current partner at Lippis Mathias, John Flynn. John, thank you so much. Appreciate you.
Thanks, Michael.